Hi again, everybody. This is Mark Movsesian. I'm the co-director of the Center for Law and Religion at St. John's Law School. And I'm joined once again by my colleague and my friend, Marc DiGirolamo, Professor Marc DiGirolamo, the center's other co-director, for an episode of Legal Spirits, our podcast series on cases and issues in law and religion. You can find past episodes archived on our website, lawandreligionforum.org, and also on streaming platforms like Apple iTunes and Spotify and Android. Well, today, Mark, we're going to return to more of our typical fare. We're not going to talk about Canticle for Leibowitz or great literature in this episode.
Back to our bread and butter issues, I guess, right?
Back to bread and butter, right? We're going to discuss oral argument at the Supreme Court this month in a case called Groff versus DeJoy, which is a case that involves Title VII, a federal civil rights law that prevents employment discrimination based on religion, among other things. And at issue in the case is a matter of statutory interpretation. Under Title VII, the term religion includes all aspects of religious observance and practice, and now I'm going to quote the statute, unless an employer demonstrates that he is unable to reasonably accommodate an employee's religious observance or practice without undue hardship on the conduct of the employer's business. And that's the language it's going to be focused on.
Good. And so we've got a 1977 case, Mark, TWA versus Hardison, interpreting some of this language, where the court suggests that undue hardship means really anything above something that is a de minimis burden. De minimis is one of these Latin phrases that we use in the law all the time. Mark, it means sort of anything other than a very, very sort of low level or trivial kind of burden.
Right. So what Hardison suggests on that reading is any cost to the employer that is above a trivial cost would be undue hardship, which would mean the employer wouldn't have to accommodate the employee. But as we're going to see when we talk about this case, there's an alternative reading of Hardison in which maybe the real test is not this triviality test, but rather whether the employer has to incur substantial costs or substantial expenditures in order to accommodate the employee's religious belief. So one of the issues in this case is how we read this earlier Supreme Court opinion. And I think there was at least some suggestion at oral argument this month that maybe the justices will find a way to finesse this, not necessarily overrule Hardison. So in some ways, this is a statutory interpretation case. It's a kind of, you might say, almost prosaic case. But as Mark and I are going to discuss, the case also raises some important issues about the nature of religious practice in 21st century America and our society's attempts to accommodate the legitimate interest that we have in religious practice with the legitimate interest that an employer has in running his or her business and making money.
Right, exactly right. All right, well, so why don't we start with, I'll run through some of the facts first, and then we can talk about some of the issues, Mark, right? So Groff, who's the plaintiff and the petitioner here, is an evangelical Christian who observes Sunday Sabbath and is employed by the United States Postal Service as a postal carrier under a specific designation, the so-called Rural Carrier Associate designation, which is a kind of non-full-time worker who is required to be flexible in hours and duties. And so the Postal Service, actually for many years, I remember when I was growing up, you just knew that there was never any delivery on Sunday.
In fact, I think there's an early controversy about this in the 19th century about whether the mails would be delivered on Sunday. And there were some people who said it would be an inappropriate establishment of religion if the mail were not to be delivered on Sunday out of respect for the Christian Sabbath. But that was gotten passed. And of course, yes, the mails were not delivered on Sunday.
For many years, right? But recently, I think it's as of 2013, the United States Postal Service began Sunday mail delivery after it contracted with Amazon. Amazon has a Sunday service delivery, so wouldn't you know it, Amazon has disrupted this ancient practice of not delivering mail or packages on Sunday. But Groff notifies the Postal Service that he has a religious objection to working on Sunday. And we should mention Groff was employed before this arrangement with Amazon. Now, there was a kind of a complicated system by which the Postal Service attempted to staff Sunday delivery and so on, with different lists of volunteers for Sunday and non-volunteers. Overwhelmingly, the majority were non-volunteers, did not want to work on Sunday. And so at first, the Postal Service tries to find workers to swap out with him, but on more than 20 Sundays, no worker could be found, and Groff didn't work. So basically, they try to accommodate him, but after the volunteer non-volunteer policy goes into effect, he's told, look, you got to work Sunday delivery, especially during the peak of our delivery season. So he transfers, and he transfers to another town and he now tells the United States Postal Service branch that again he won't work on Sundays, and the new branch offers him a deal. It says you can either attend religious services Sunday morning and report to work afterward, which is an accommodation, by the way, that other employees were given, or they will try to look for coverage. And so he opts for the second course, and the Postal Service struggles. The postmaster himself delivers the mail on Sunday to cover for Groff. He's got to pay overtime to others. And there's a testimony, Mark, in the record that all of this contributes to bad morale in the office.
Right. I think there was some indication that one of the other employees quit, right, at some point because they didn't want to do this anymore.
Exactly. And so this attempt to accommodate him works maybe for a little while, but not so well. And eventually the system breaks down and he's disciplined for not working on Sunday. And the Postal Service says, look, pick a different day to observe the Sabbath, which of course he's not going to do.
Right.
So eventually he resigns, and after filing some equal employment opportunity letters and obtaining no relief, he then sues the Postal Service, and he really brings two claims for religious discrimination under Title VII of the Civil Rights Act. The first for disparate treatment, which is not at issue in this case, and the second for failure to accommodate. So at the district court, he loses. The district court says that the Postal Service offered Groff a reasonable accommodation in the shift swapping solution that the Postal Service and that the Postal Service had evidence of several examples of what the statute calls undue hardship in providing an accommodation, especially the need for other employees to work every Sunday without break. And then he appeals, and he also loses at the Third Circuit.
Yeah. Now, what did the Third Circuit say, Mark?
It said, first, Title VII prohibits discrimination against employees on the basis of religion. There's no dispute that Groff has established a prima facie case of discrimination on the basis of religion. Why? Because he's got a sincere belief. He informed the employer, and he was disciplined because of that belief. But the Third Circuit says, once the employee shows that prima facie case, now the burden shifts to the employer to show either, number one, that it made a reasonable good faith effort to accommodate the religious belief, or number two, if it didn't, that an accommodation would work an undue hardship on the employer.
Right. So and I should say, by the way, I said a second ago that one of the other employees quit. I'm not sure that's true. I have to go back and see, but there certainly was evidence that Groff's requests not to work on Sundays definitely interfered with morale, because other people, the court says, diminished employee morale because his other co-employees had to cover for him and they had to miss their other events that they wanted to do on Sunday. At one point, I think the postmaster himself had to deliver the packages because, right? Am I right about that?
That certainly is right.
Right.
I agree with you. I'm not certain that somebody actually quit because of it. And this actually came up in the argument, I think.
Correct. It did.
So we'll talk about that.
Okay, fine. Okay, Mark. So what did the Third Circuit say about undue hardship here?
Okay, yeah, right. So on reasonable accommodation, before we even get to undue hardship, the court said, look, reasonable accommodation is an accommodation that eliminates the conflict between the religious belief and the business practice. That didn't happen here, right?
Right.
So if that's what's required, clearly they don't meet that. Okay, so when moving on to the undue hardship analysis, the Supreme Court held, in this case that we just talked about, the Hardison case, that an undue hardship is one that results in more than a de minimis cost to the employer. And because that's not a particularly a high threshold to cross, the Third Circuit decided it was clearly crossed here. The accommodation imposed on Groff's coworkers, it disrupted the workplace, it diminished employee morale, it strained the whole system. So at the Third Circuit, he loses.
Yeah. So, and the question presented on cert is whether the court should reconsider the Hardison rule with respect to what constitutes undue hardship. That was the question on which cert was granted. But during oral argument, it was interesting to me, Mark, that some of the justices, and I'm thinking principally about Justice Kavanaugh here, suggested, well, maybe actually Hardison shouldn't be read to say that undue hardship means anything above a de minimis burden. Because although the court said that for sure, there's language in the Hardison case that says that. And Mark, you and I teach law and religion, and this is certainly the way I've taught law and religion, that undue hardship means really sort of nothing, right? Anything above a trivial thing. But Justice Kavanaugh said, well, if you go back and look at Hardison, there are indications in Hardison that actually there were substantial costs and substantial expenditures that the employer, TWA, would have to have incurred in order to accommodate the employee. So maybe this language about de minimis really it's sort of dicta or needs to be clarified. And maybe rather than overrule Hardison, what the court can do is say, well, we just want to clarify that even though we have this de minimis language, really that's kind of dicta, because really Hardison is about a situation where the employer would have to incur substantial costs. So I'm getting to the end, listeners, so that the test would actually be substantial costs, not de minimis.
Yeah, so I think Hardison is kind of a mixed up opinion a little bit on this ground.
In the way many of the opinions from the 1970s are, I think.
Yeah, and it seems to incorporate different standards in different parts. The standard that you're talking about, the substantial cost standard, you can find it, and Justice Kavanaugh noted this at footnote 14 of the case. The de minimis standard is within the basic text of the principal text of the case. So I would think, and you're right, there's a question about the interpretation of Hardison, what Hardison really says.
Yeah, I should point out that I always, as students, if you're listening to this, I always tell you, when you become judges, don't put major parts of the opinion in the footnotes, right? Don't put substantive reading in the footnotes where people aren't necessarily going to see them.
And look, I think the major argument in petitioner's brief is a challenge to the de minimis standard of undue hardship in this case. And so I think in one way or another, the court is going to have to confront this language. Now, what it does, whether it decides to kind of, because there's also a question about the stare decisis effect of this language, whether this language was necessary for the holding, which some people say it was not. Other people say, no, it was necessary for the holding. And so this usual problem of what's holding and what's dicta appears in this case and was probably going to have to be resolved by the court as well.
Yes, I think so, Mark. But the court frequently, I'm not talking about law and religion cases now, but the court frequently will say things like, well, we understand that there's language in our earlier decision that might lead judges astray, and we just want to clarify that right now, that to the extent that Hardison can be interpreted to mean that undue hardship means anything above a triviality, well, the opinion doesn't mean that. The opinion actually means that undue hardship means something in the nature of substantial costs to the business. I could see them saying that rather than overruling Hardison, because overruling cases is not good for the franchise generally, and besides, courts do this all the time.
It could be. Look, I mean, plaintiffs or petitioners rather say the standard should be what they argue for is, quote, a significant difficulty or expense in light of the employer's financial resources, the number of individuals it employs, and the nature of its operations and facilities, right? So standards that accord with the ordinary meaning of hardship as something hard to bear, suffering, right? As well as with other statutes, by the way, like the Americans with Disabilities Act, right? Undue means unwarranted, not just a hardship, but an unwarranted hardship.
Well, and something serious. And actually, one of the justices, I think it was Justice Gorsuch, said, Congress doesn't normally pass civil rights statutes that can be, the effect of which can be blunted by a showing of some trivial problem.
Right. No, I think that's true. Now, I guess the issue then becomes, as between the language in footnote 14 and the standard that the petitioners seem to be asking for, and this I think is something that came out in Justice Thomas's questions, but also in Justice Gorsuch and in Justice Jackson. Is there really that much daylight between the standard that you're looking for and the if we take the standard that the government is now arguing is the actual standard or that could be extracted from footnote 14, is there really that much difference between these two?
Yeah, in a way, it reminds me of, is it the Shurtleff case from last term where it was the flag at Boston City Hall where the justices were kind of scratching their heads and saying, why haven't you settled this case? I mean, what is the real nature of the dispute here? I had the same sort of sense here. The justices were looking for a way to kind of get rid of this case or decide it in a kind of narrow way, because it didn't seem like there was that much difference between what the petitioners were saying and what the SG on behalf of the Postal Service was saying.
There was another interesting point, Mark, that I wanted to raise with you on the stare decisis issue. This question about stare decisis being especially important or especially meaningful when we're dealing with the interpretation of statutes by contrast with the interpretation of the Constitution, because the idea is if Congress doesn't like what the Supreme Court has done in the interpretation of the statute, it can always intervene. And some of the justices pointed out, Justice Kagan, for example, pointed out that Congress hasn't intervened with respect to the issue decided in Hardison, while it has intervened with a number of other on a number of other issues involving Title VII, where it hasn't liked the court's interpretation.
Right, and the standard rule, again, this is not a law and religion rule, but the standard rule in statutory interpretation is that if the court interprets the statute in a certain controversial way, and Congress does not amend the statute to address that controversial interpretation, then under the theory that Congress has acquiesced, we just assume that that was the correct reading of the statute.
Yeah, and Justice Alito asked kind of an interesting question in the argument about whether a different understanding of the religion clauses, and especially the Establishment Clause, explains the result in Hardison. So the adoption of the de minimis standard in Hardison was the result, he says, of a kind of view about the necessity of the government to be strictly neutral when it comes to religion, lest it violate the Establishment Clause. So adopting those tests and then the subsequent failure of Congress to intervene was a kind of the idea was that Congress didn't think it could intervene,
right,
to correct a problem that it thought was necessary, or an interpretation that it thought was necessary in order to comply with the Establishment Clause. So the reason for congressional inaction of the kind that you're talking about in changing the de minimis test might well be that Congress didn't think it could do so consistent with the Establishment Clause.
Right. So the idea is so Hardison is 1977. That's the height of the Lemon versus Kurtzman era. And Congress might have thought, well, we can't change this anyway. And that's why. And you're right. Justice Alito said, well, Lemon is gone now. At least I think it's gone, listeners. I mean, you never quite know, but it seems to be gone after the Kennedy case from last term. So, now that has changed. And so maybe Congress would want us to interpret the statute somewhat differently. But Mark, Justice Jackson had an answer to that, right?
She did. I thought it was a pretty good answer. She said, well,
me too.
Why they can intervene now, right? They can interpret Supreme Court case laws, the difference in Supreme Court direction with respect to the Establishment Clause as well as anybody else. And if they want to intervene to change this particular issue under Title VII, they can sure well do so.
No, right, which I think I agree with you, Mark. I think that's a very good argument. It's also a standard argument in statutory interpretation cases. If Congress wants to do something, Congress can. Now, we all know, given political realities, it'll be very hard to get anything through this divided Congress on a question of religious liberty, because religious liberty has become so electric a topic, so neuralgic a topic, that it's just hard to imagine Democrats and Republicans being able to agree on anything with respect to religious liberty right now. But of course, that's neither here nor there from the perspective of the court. I mean, the court does what it does, and if Congress, for whatever reason, can't get its act together to change things, well, that's really Congress's problem.
Yeah, no, I think that's right. Although the de minimis language is the court's problem. right? I mean, that is a standard that the court has imposed, and so it should be the one to be responsible for cleaning that up if it's a mistaken standard.
Yeah, so these are all really interesting questions for those of us who are law professors, all about statutory interpretation. But many of you listeners might be thinking, well, this sounds like a rather dry, prosaic sort of case. I mean, why is this gaining all the attention that it's gaining? It's just a matter of interpretation of a couple of phrases in a statute. And Mark, I think the reason why this case has touched a nerve is because whatever verbal formula we come up with, whether undue hardship means something more than a trivial cost, or something more than a substantial cost, or something like this, or a substantial cost, whether we think it means trivial or substantial, in the end, the courts are going to be balancing these things in the context of specific cases. And a few of the justices said, we can't come up with a categorical answer here. This is going to be a case-by-case determination about whether an employer has done enough to accommodate the religious practice of an employee. And that gets us into some topics, Mark, you and I have talked about before, which is, at the moment in American society, it's just very hard to come up with kind of consensus background norms that will allow us to resolve these problems in a predictable way.
Yeah, two quick thoughts on that, Mark, and I agree with you. Of course, this picks up on some of your previous work with respect to disagreements concerning the COVID rules, which really came to the surface when justices had to make kind of snap decisions about which one would win, which overriding concern would win, the concern of religious claimants or the concerns of sort of public health advocates and so on, or the government.
Yeah.
And so it's in that way, it's a kind of a similar situation. And the second point is, and I agree here too, even if we adopt substantial costs, the question is, well, isn't that standard satisfied here?
Yeah.
I think Justice Kagan, Justice Barrett, Justice Kavanaugh, they asked, I think, very powerful questions. Kagan asked, why shouldn't the burdens on employees and the inequities imposed on them count in the undue hardship calculus?
Well, bad morale, right? So if I remember the argument, that the claim that petitioner was making is, no, you have to show undue hardship with respect to the business. You have to show some genuine business loss, like, I don't know, they're in the red, they're not in the black, or something like that. And a few of the justices, including Justice Barrett, you're right, said, well, isn't bad employee morale, isn't this a matter of common sense? Isn't that going to affect the business? I mean, do you have to really show an accounting, a kind of spreadsheet and show where the costs are? And I don't know about you, Mark, I have some sympathy with that. I mean, I have sympathy for people like Groff who want to practice their religion and are not able to because of what the employer says. But I also have sympathy for the employer who's got a business to run and a payroll to meet. And it seems to me it's a tough balance here.
Yeah, I blame Amazon. I think that's obviously the bad guy in this situation.
Yeah, why is that? Why is Amazon
because they were the ones that stimulated this new
change,
contract, this
right.
change, right? I mean, the post office was going merrily along without any Sunday delivery service, and here comes Amazon and the demands of the new digital economy and disrupts everything. I mean, only half joking, I think.
Well, we have a past podcast about this, about Sunday closing laws. We did it around New Year's, if you remember, because there's a New York statute that says you can't sell alcohol on Sundays, and including when New Year's falls on a Sunday. Listeners can go back and listen to that podcast.
No, and look, I think this does get back into the issue of whether it's important for a society to come to agreement about a day of rest, right? And the Sunday day of rest, obviously, that's the traditional Christian day of rest. These are issues that go all the way back, well, at least as far in Supreme Court law to McGowan versus Maryland, and so on. But of course, much deeper than that. They're about the common culture, as you suggest, of the society, and whether America has such a common culture any longer, or whether various business and other concerns, whether they are the common culture now, and all other issues must yield to, all other concerns must yield to those primary concerns.
Well, I mean, I think it's going to be a problem in a pluralistic culture. I mean, you can make the argument, the Supreme Court has made the argument that Sunday is the day of rest for historical reasons, that this is not a matter of the Christian Sabbath, but I'm not sure that persuades everybody. And there are increasing numbers of people who celebrate a different Sabbath, and they will want to take their time off. And if I'm an employer looking at this and okay, we have some people want the Friday Sabbath, some people want the Saturday Sabbath, some people want the Sunday Sabbath, that becomes a very difficult thing. So, and how this gets resolved in the context of a particular case, whatever the language is, whatever the semantics, whatever undue hardship means, you're basically going to be balancing these seems to me, two important goals, legitimate goals, which is, okay, people should be able to practice their religion, but businesses should be able to run their businesses too.
All right, it's prediction time, Mark. How do you think this case comes out? What do you guess?
So it's always hard to know, and don't hold me to this, but looking at the argument, my sense was that there were a few votes for the proposition that Hardison has been incorrectly understood, that the correct understanding of Hardison is substantial cost, not anything above a trivial cost. And I think you could get a plurality opinion that says let's clarify that is the test, and then remand to the Third Circuit. But I could also see them saying, okay, that is the test, and there have been substantial costs here. I'm not so sure about that. I think more like it'd be a remand. And then you might get separate opinions. You might get, Justice Thomas seemed to think that actually Hardison isn't about Title VII at all, but rather about the EEOC regs that were extant at the time. And I'm not sure Justice Alito is going to go along with this either. He might want to just overrule Hardison. So I would suspect, and then I think that Justices Kagan and Jackson and Sotomayor will probably be on the other side of this. So I would guess the vote will be 6-3, but I would guess maybe a plurality opinion. That's sort of that would be my guess if I had to guess right now.
Yeah, that sounds.
Wait. What about you?
That sounds. I was going to say that sounds entirely reasonable to me. I think the de minimis test is going to go down. I don't think that the textualists on the court, including Justice Gorsuch, whom I agree was looking for a kind of middle position, I think it's going to rub him wrong that you've got this language there. So the sort of don't worry about it because courts really know what it means yes. argument that the Solicitor General was making, that will not persuade
that will not
a majority.
Persuade. But do you think they're going to have a majority to overrule the case?
I don't know, and it might be that both Justices Gorsuch and Kavanaugh were looking at this other language. I think that's a more difficult question: is what replaces that test. Whether that test, certainly the questions that you were talking about, how that test is applied, whether that requires overturning Hardison in part depends upon the holding/dicta debate that we were talking about, and how the de minimis standard fits into that context. So the justice is going to have some kind of agreement about that position. But I could certainly see a non overrule, but with a disavowal or something of the de minimis language and an enunciation of a new standard that courts now all have to apply. Which by the way, both I think it was Justice Alito, and there's a brief, an amicus brief in the case says it's not true that courts are really they just kind of know what it means, and I think courts are kind of all over the map. Mm-hmm. on the question, and a number of religious claimants have suffered because of the de minimis rule, and I have a feeling that a majority of the court will want to clear that up.
I think so, but if I'm right, that ultimately whatever language you choose is not going to end the need for balancing, then the courts are going to be all over the map no matter what the linguistic standard is. But so we'll have to see. So the court will decide this case by the summer, and then Mark and I will be back to talk about this case, and there are, of course, a couple of other religion-inflected cases on the docket. There's a 303 creative case that we'll talk about also, which is not strictly speaking a free exercise case, but certainly has free exercise overtones. So there's some other opinions we'll want to talk about too. But for now, this has been Mark Movsesian and Mark DiGirolamo with another episode of Legal Spirits, the Center for Law and Religion's podcast series on cases and issues in law and religion. For past episodes, you can look to our website, lawandreligionforum.org, and also you can find past episodes on streaming platforms like Apple iTunes and Android and Spotify. But that's it for now. See you next time.